And I'm going to dive right in if that's okay with you. And Ryan's going to kind of help me make sure as we go that if questions pop up along the way, I'm going to do my best to answer those as we go. Please don't hesitate to dive in and use that chat function to let Ryan know if there's something that you want me to pause and go back to or address as we're going. So I titled this California Criminal Law and Common Sense, a win-win. And by common sense, I really mean taking a more common sense problem-solving approach to teaching criminal law to undergraduate students. It's something that means a great deal to me. I have been teaching for many years now, and absolutely love teaching this course, teaching the substantive criminal law to undergraduate students. At our institution, this is a lower division course, and I know that at many community colleges in the Administration of Justice program, this is a course that's included as a required course. And so very often I'm getting students in this class who are early in their academic careers, freshmen and sophomores. They're completing that lower division requirement to attempt to get in the major here at Sacramento State, which some of you know, Sacramento State's program is a large criminal justice program. We have right around 1,800 students in our criminal justice major. So this is a class we teach a lot of sections of at Sac State, and I have the great privilege of teaching this fairly often. So I want to dive in and talk about just some of the challenges that I've seen teaching the substantive criminal law to students along the way. And kind of make the case for why I love teaching it the way I teach it and why I think it helps address some of the challenges. So without further ado, let's see, I'm gonna go, yes. So I think one of the first things I wanted to address is just that initial premise, the idea that some people have that undergrad students just can't do it. I know that I've talked to faculty who are tasked with teaching this course, and sometimes there's just this frustration in their voices where they say, you know, if they are attorneys, and often they are, they might be adjunct faculty or full-time faculty who are attorneys by training, who are teaching this class, and you can see that that frustration with trying to modify the way that we learned the law or that they learned the law as a law student, and the way that they understand the law from their practice experience, and then delivering that to undergraduate students in a way that is going to make sense for them. Many have tried a wide variety of textbooks and course methodologies. Some have tried a pretty traditional university series text that maybe just has those, that has chapter content that is substantive and just offers the kind of survey information about the law. The kind of bold type terms and traditional end of chapter questions. And all the way to folks who, when I arrived at Sac State, they were using the Perkins and Boyce law school series case reader to teach freshmen and sophomores the criminal law. It was a significant challenge. And so I think across that spectrum, I have talked to faculty who just sort of wrestle with where's the balance between enough rigor and enough challenge and accomplishing the things that we love about the way that we learned the law in law school, the things that were meaningful to us, while maybe kind of getting rid of some of those old-fashioned approaches that weren't so helpful to us. I think some new approaches ignore sort of the importance of that critical evaluation piece that we enjoy from using the case briefing method of study or case studies, case examples. And so I think there's a way to marry those things in a way that's meaningful. I'm going to open the chat just so I see. All right, and I'll keep going. Let's get rid of that. And so why do students need to learn the law? You know, why do we include this substantive law course in every criminal justice curriculum? Well, of course, it's criminal justice, right? This is a critical area in the interdisciplinary kind of nature of our universe of criminal justice preparation for future practitioners, for folks who are going to work in agencies, for folks who are going to go on to working in criminal justice adjacent careers like community counselors and developers. It's critical for all of those folks who come through our program. So they have to know the substance of the law. And that's that first piece that's so important for us to impart to them is what is the law? And so of course we spend a great deal of our time when we're teaching criminal law trying to impart that, what is the criminal law? How does it function? Rape, robbery, arson, homicide, what are the actual crimes and the elements of those crimes, that content specific work that we're doing. So that's, of course, really important. But just as importantly as that, I would argue, is that our students need to and benefit from acquiring those legal reasoning skills that are sort of the inherent piece of what's, I always look back at my law school experience as that miraculous like reshaping of the way that I learned to approach problems and the way that I learned to think in a problem solving kind of way. So teaching students the how and the why in the context of how the law has developed, using practical examples from real cases, I think achieves both of those goals. Both of those ends are met by using a marriage of that approach that enables both the substantive law acquisition, and also the critical thinking, that problem solving and analytical reasoning. So I love that. I like this. We're seeing a little bit of a poll. Some of you have used a case study kind of model in your courses, and some of you haven't. That's excellent. I think that's very typical. I think it really depends on sort of your background and experience, the culture of your program. Sometimes like I said, when I walked into the program at Sacramento State, I had senior faculty who said, hey, this is the text we've been using, as is common, right? So I was brand new faculty in 2002, and they said, hey, this is the text that we use. We like this. They were very committed to a case study approach at Sac State before I got there. And so I walked into that culture and said, okay, I'm going to learn how to teach this well. And one of the very first things one of the very first encounters I had was with a senior faculty member who was getting close to retirement, who said to me, what we do, he believed in deeply the way that we teach the law. But he said, we've got to find an approach that is more meaningful to California-based students who will likely be California-based practitioners. He was frustrated that we weren't teaching them California law. And so that was an encouragement that he gave me early. He said, someone needs to write a book. And I was like, you're crazy early in my career. But after a season of teaching this long enough, that's really what led me down this path to deciding, hey, I really want to teach California specific rules. I want to teach California specific statutes. I want to teach California specific cases. And I want to do this in a way that really goes beyond just my ability to assess in an objective multiple choice format, that these students know what burglary is, or that these students know the key elements of arson. I wanted to know that these students could think critically, and when faced with significant challenges out there in the field, that they could solve problems and that they could evaluate the evidence around them in a set of circumstances and make right-minded, thoughtful decisions. And so for me, that's the driver. Absolutely the driver. So that's really interesting in terms of your experience. I appreciate you guys sharing that with us. Let's see, what is next? And so Ryan, definitely tap in here if you have, if you see questions popping up for me. I don't want to just keep racing through if questions pop up as we go. So my thought process about approaching the criminal law a little differently, especially for those of you who haven't tried that case study approach, or maybe if you've tried it and you've been trying it with different kinds of selections of cases, is that what I've done is I like to use kind of a modified case law approach, where I do teach those substantive principles of the criminal law. I like to go through what kind of feels like for students a pretty typical university series kind of textbook. So I like for the students to have that comfort level of reading the chapter and seeing some examples and having some key terms at the end of the chapter and some flashcards and some things that feel, especially for my freshmen and sophomores, things that feel comfortable in the context of learning for them, things they've done before. It enables me to do some quizzing that feels very natural and feels like it's not the first time they've seen it before, because I am going to use some assessment tools that they haven't seen before. So I do like to have that marriage between the two. And that's why I say I use a modified case law approach. I do allow my students to really try to gather their understanding of the material on the front end of each chapter or each new topic area in a similar way that they might have in their other coursework. And then we kind of transition to reading those cases and learning how to brief those cases and really walking through that process that is, as you know, it's an analytical exercise. And I tease them always at the beginning of the semester that they're going to be developing these critical thinking and analytical reasoning and problem solving skills, and they won't even know it. They'll be acquiring these incredible skills in a way that is so meaningful, and it's at the same time really interesting and a lot of fun. So I kind of have that two-step approach to every topic area when I teach a criminal law course. So we first walk through the substance, and we first walk through that pretty traditional textbook exercise of learning what the terminology is for that particular area of law, and we walk through understanding who the players might be or how that kind of is defined. I always teach an elemental approach, and of course I always use statutory context. So I always give them reference to the California statutes that govern. If occasionally, if important, I might give them context and tell them how it might be different in other jurisdictions. But I really do, in my kind of philosophical delivery is to stick to the California rules to the best of my ability. And of course, overarchingly, sometimes there are big constitutional principles that we'll bring in, and we'll talk about how there might be comparison to what other states are doing. But I love to marry that with those case studies, which are always their favorite part of what we do. And so when I talk to students and I read their feedback after the fact, the case studies are always something that they love. They're all California cases, so very often students can identify with the geography of the cases. They'll know where the cases took place. It gives them context. It makes it really feel sort of exciting. And then, of course, I can use assessments to discern whether they've acquired that content on the front end, or those basic elements, and have they acquired an understanding of what the law is in a particular area. But I can also use some creative assessments to kind of really discern whether they're acquiring those analytical skills. And that's, of course, really, really important to me, because the critical thinking and problem solving skills, I think, are maybe the most significant takeaway from this introductory criminal law course that's going to be the first, for my students, the first in a series of law courses that they'll complete as they earn their bachelor's degree in criminal justice. Okay, I'm going to take a breath, and I'm going to just look really quickly at how
Laurie,
yeah.
Christine has some feedback on using the case method in her course.
Okay.
Her students are having trouble. Her students are having trouble getting to understand what the holding of a case means in the bigger picture.
Okay, and you know what, I think that's a great question. I have, I'm sorry, I'm flipping back to where we were to try to see where I want to land for the moment. Christine and others, I think one of the things that I have struggled with, and I have a lot of colleagues, we have a pretty big faculty, so I have multiple law colleagues, we all teach the same courses, and sometimes we'll talk about the way that we teach briefing, and some of us learned briefing a little differently. So I am old enough, I think, that I learned that very traditional kind of FIRAC, facts, issue, rule, analysis, conclusion model. And I think that the way that I have tried to deal with, I think, the problem that you're describing, which is divorcing and really dissecting and separating out the holding of a case, which is just the outcome today, right? The outcome for these two litigants today, or this litigant in a criminal appeal. This litigant thinks that his conviction should be overturned because something was, there was an instruction to the jury that was inappropriate, whatever the case may be. So I think a lot of students hang on the holding as really the outcome for that litigant. And I always talk to the students about being far less interested in the outcome for this litigant today, contextually, because obviously it matters a great deal to that person in the context of their appeal. But for us in learning the law, I'm always far less concerned about the holding from the perspective that what's the outcome for this person in this appeal. I'm always much more interested in understanding and really parsing out that distinction, that old-fashioned distinction between the rule of law and the application or the analysis. So in that old-fashioned FIRAC model, you know, the students, we had to, as law students, we had to discern out and parse out, and a lot of times really wrestle and tease out the distinction between what is the rule and what is the analysis or the application of that rule. That exercise is the piece I absolutely recommend sticking with. So some undergraduate faculty will modify the case briefing model. And so instead of forcing students into that really tough intellectual exercise of trying to parse out the distinction between rule and application of rule, they'll have the students approach the case brief by saying, here are the facts, here is the issue, here is the holding or the outcome, and here's maybe they'll utilize a rationale section. That's a very common kind of model. And so instead of really being able to see how the law functions independently of the facts, the students often can only understand that particular outcome in the context of that particular case. And so then if you go to ask them a hypothetical essay question for an exam, they have a really difficult time because they can only understand that concept in the context of that story that they learned it in the case they read. So the way that I've dealt with that is that when we go through a case and we walk through the briefing together, I always ask them to separate out what do we think the rules of law are and what do we think the application of those rules looked like in this case. And then, and so when we do our case brief together in class and kind of a very modified Socratic exchange, not the kind of hide the ball exchange that some of us experienced in law school. Instead, I'm kind of like a telegraph the pass Socratic exchange with my undergraduate students' work because I want them to discern out that distinction. I'm looking to make sure that they've parsed out that distinction between rules, legal rules, and principles that we are going to then hold on to and apply later to new and unique fact patterns. I want them to get that distinction between that and its application today. And of course, the outcome or holding in the case that we're looking at today. So I think that's the way that I've approached trying to overcome that hurdle. I think that's an absolutely, I think that experience is shared. I would say you probably share that experience with others. And I think that's been the way that I do it. I do a lot of hypothetical exercise in class. So when I'm going through a case, and I'm talking about what did the court say the rules were? How did the court apply those rules in this particular instance? I often then will ask them follow-up. We'll follow up with hypotheticals, sometimes even in small groups, and I'll say, I want you guys in this group over here to imagine that the facts changed slightly. And so instead of X, Y, and Z being true, now for your group, A, B, and C are true. So I modify those facts for them so that it forces them to think, okay, in the real case where X, Y, and Z were true, this was the outcome because the court held that the rule applied in this particular way. But if I have to pretend and assume for the purposes of this hypothetical that instead of X, Y, and Z, now A, B, and C are true, and if I, as a teacher, make A, B, and C different enough, but maybe not so different that it's a complete stretch for them, where my students have to sit and really sit with and think about, is this different enough that I think the rule would apply differently? That exercise has been extremely helpful. And so I might do that, whether I do it from the front during that kind of Socratic exchange lecture piece, or whether we break up and we do maybe small grouping exercises, or even take home or writing exercises where they might reflect on, how do you think the outcome of this case would be different if the facts were modified? That prepares them for application to a brand new set of facts that they've never seen before. And so if we kind of take some steps between the original set of facts and the hypothetical exam that I'm going to give them down the road, if I kind of work them by step through a process of learning how to do that, it really does help. Okay, does that help answer that question?
I love that idea of, modifying the facts of a case. Do you do that with every chapter, or is that just a few select chapters?
I do. I utilize, now the textbook that my textbook that I use has a lot of cases. I do not utilize all of them. It's many more than I think in a 16-week formatted semester I could get through. I typically pick and choose. I always choose at least one, but I pick and choose. In a longer, more dense chapter, I might have them walk through, like for example, the homicide chapter. I have them walk through at least one of each type of homicide. So we do at least one first-degree murder case, at least one second-degree murder case, at least one voluntary manslaughter case, and at least one involuntary manslaughter case. I usually do a couple more than that in the homicide section. I spend a fair amount of time there, and so I might pick a couple of cases for each of those topics. But for other topics, I might decide that I can get away with just one case exercise because I think maybe it's something that is ascertainable in with less of that. And of course, it all is also dictated by time. And from semester to semester, the group of students that I'm working with might drive how many cases I'm getting through. If I have a really engaged classroom, we might only have time to get through one per section because maybe it's taking us a couple of days of class time to walk through a really dense case. Whereas if I have a group of students who just seems to be moving more quickly, and that's not always because they are because they're doing better or worse work. It isn't always, pacing isn't always driven by quality of work. Sometimes it's just you have a group of students who just moves and they're moving more quickly than others, and so that's just dictated by time. But I do utilize at least one case in every subject area. So for me, that would be at least one case in every chapter, but even more than that, because I would utilize a case in each subsection most of the time. That's a good question. Okay, so my modified case law approach that I talked about, kind of marrying the old and the new. Yeah, I think I got through this. Why critical thinking matters. I suspect I'm absolutely preaching to the choir here, but I think it's always good to just be reminded, and I pulled this quote that I just love. The ability to think critically has been associated with wellness and longevity. Though often confused with intelligence, critical thinking is not intelligence. Critical thinking is a collection of cognitive skills that allow us to think rationally in a goal-oriented fashion, and a disposition to use those skills when appropriate. And that comes from Heather Butler's article, Why Smart People Do Foolish Things, which I think is a very entertaining title. But I love this idea that critical thinking is not something that is unattainable for any student in your spectrum of academic skills. So you may have highly skilled students who come into the classroom already very well equipped to learn. And you might have skills. If you're an institution like mine, I serve a lot of first-generation college students. Many of my students have no one in their personal experience who's ever gone to college. So as first-gen students and as outreach students, which I would argue, and if not a near majority of my students fall in that category, I'm walking them through an academic exercise that's probably new for them. And so they aren't coming to me necessarily with all the skills they'll need to be really successful as college students. And my hope, of course, is really successful practitioners on the other end when they get done with our program. And so it's so important to me, and I'm so committed to making sure that I do my best in this early course in the series to equip them with these critical thinking skills, because I think regardless of overall measures of intelligence, critical thinking is a collection of skills all of our students can gather. And so if we deliver, I think, this course the right way, we're going to walk them a long way toward that end. And I think that, again, I said this at the beginning, but I think it maybe is the most important thing we do in this class. The law changes. So I can teach them what the elements of burglary and arson and robbery are today in California. And while, of course, substantive criminal law is not an enormously transitional area of law, but still there's movement. There's movement from state to state. There are trends that change. There are things that evolve, and the law is a bit of a moving target. But the skills that we impart to them, if we really deliver to them great critical thinking and problem solving skills, those skills translate. And as the law changes, they can move with it. And that to me is incredibly meaningful. Yeah, so in practical terms, I think it equips students to solve problems, and that is a skill that just transcends the academic experience. And for us as criminal justice experts, as people who are training our next generation of criminal justice leaders, I think what we really want when we look at trends, and we want to see folks evolving in the way that they deliver public safety and the way that we deliver the kind of correctional care and rehabilitative efforts and all of the things that we're trying to do broadly across the spectrum of criminal justice. I think students with great critical thinking and problem solving skills is an like when my heading was, it's a win-win. It is a win-win. It's great for us in the classroom, but it is a win for us out in the community if those tools go to work with them when they graduate. So, and of course, Ryan, you do not hesitate to jump in here if you have another question pop up.
I do.
Okay.
How have your students responded to this method of teaching the course?
My students love this. And I mean, to kind of storytell, to go back, when I first taught in a university setting, sort of by accident, I was an attorney working fresh out of law school. You joked about the fact that I was working with as a player agent with football athletes. I was doing that, and I was actually doing I was working in a law firm doing constitutional law work at the time, which as a criminal justice undergrad, con law was as close to my wheelhouse as I could get. And I was working in the private sector. And so I really loved it. And I was doing things that I really enjoyed. I did not dislike the practice of law, but the opportunity to teach surfaced. Sort of one of those things that, you know, I got a call from my mentor from my undergrad who said, hey, we need someone to jump in at the last minute. Would you teach a legal research and writing class for us as a part-timer? And I thought, sure. I was fresh out of law school and, of course, bearing the great burden of law school loans, and thought, absolutely, I will do that. And so I taught that first class, and it was legal research and writing for undergrads in a program there at Cal State Stanislaus that required that for every criminal justice major. So you can imagine I had a lot of students who didn't plan to go to law school, who really didn't think they should have to take legal research and writing. They didn't see how it was going to be very useful for them. But I'll tell you, in that very first teaching experience that I had, I feel like I took what I knew to work with me, which I was fresh out of law school. And so what I knew was how to read the law, how to read cases and do legal research. And that was what I had done. Most of my practical experience had been as a law student and as a young attorney. And so I went right to what I knew, and I used the case briefing method in that very first class. And I had them do an exercise that was extremely difficult, really a law school level research and writing exercise. And I made them argue in a moot court format, sort of an appellate case. And this group of students who came into the course just not happy to be there and really almost like unwilling, like just not thrilled to have to do a legal research and writing class because it just wasn't what they thought they needed. At the end of that class, they loved it. I loved it. That was it for me. That it was over. I said, I want to teach anytime I get the chance. And I told my old mentor, I said, hey, every semester you have a class for me, I'll take it. And so I started teaching in January of '98, and I've taught every semester since, in 2002 going full-time, with the exception of one maternity leave for one of my 3 children. I finally took a semester off, but But the transition for me was from the practice of law to teaching really grew out of the fact that my students loved this, and seeing them love it and seeing them be able to do it was really meaningful to me. At Cal State Stanislaus, it was not an institution that had typically at that time, and this was many moons ago, at that time wasn't using that kind of case study approach. I didn't have that experience in my undergraduate criminal law class. I had a much more traditional university textbook experience, very different than the way that I teach the class now. And of course, selfishly, I think the way that I teach it is a lot better. I love the way I teach it now, and I see such a good response from my students. So, and I'm teaching students who come to me often with a great need for remediation in areas like writing. So I am teaching this way to a group of students who is challenged. So I'm not getting the highest performing students in my lower division crim law class. I'm getting students fresh out of high school, sometimes community college transfers who didn't pick up this class in their AJ program over at the community college. But most often, I'm teaching this class to lower division students, freshmen and sophomores, who really need academic support, and they do it, and they do it well. And it doesn't blow my mind anymore because I've been doing it long enough. But it used to just blow my mind that they could do it. And I would be so excited at the end of the semester when I'd see their work improve and I'd see those essay answers and just be amazed at what they could do. I'm not amazed anymore because I know they can do it. But yeah, the response is great.
I have a question too from a Facebook Live viewer.
Okay.
You had mentioned the exercises and assessments. What do you use to assess students' comprehension?
So my kind of favorite go-to tools are a couple of things. I require them in the early going, I collect case proofs from them in terms of kind of homework and hand-holding. I do that in the early going to make sure that they are acquiring the process of case briefing and that they're understanding. Really, I talked earlier about making sure that the students are able to parse out that distinction between the legal rules that the court is utilizing and then the application of those rules to that particular set of circumstances or facts. And so I do require some homework on that end. Of course, they're reading. In my universe, homework is reading. They read for every class session. They should be. I hold them accountable to that reading by requiring them to speak up in class. And so I typically don't go as far as sort of that mean-spirited, scary law school call on you sort of approach, because usually if I let them know that that I am kind of tracking their engagement, they do a pretty good job of staying engaged. And I track that engagement literally by having like a roll sheet where I if they help me with a case or if they engage with me, I'll in the early going, and I don't know their names because I have a lot of students. I teach typically a section of 60 to 65 students. I will ask them, hey, remind me your last name, and I'll literally track who's engaging with me. When I do that in the early weeks, it helps keep the entire course over the 16 weeks pretty engaged. And I have to do less of that as I go. So I do some homework kind of work that is reading and case briefing. I'll do some review of that in the early going. I don't require them to turn in every case down the road because I can't turn them around. I have over 200 students a semester, so I can't turn around the daily case briefs if I were to collect the briefs every single day. So I don't do that. But I do in the early going do some review and feedback to make sure that they're getting on track. And I always volunteer to review cases if students are struggling. So, and of course, there's a few who will always take me up on that down the road. You know, if they need additional help, I'll always do that. In terms of assessments that are, you know, graded assessments, those homework kinds of assessments, I typically do not grade for a letter graded. I don't take a letter graded approach to those homework pieces. I typically take a letter graded approach to quizzes and exams, and if I do a writing project, and I've done a variety of things. Some semesters I've taken the case briefing assignments and created a writing project out of it and had them turn in what is essentially a journaling project of all of their case briefs. Some semesters, every semester, I utilize both objective elements in an exam taking setting, so closed book, timed, in-class exams, if I'm teaching on the ground in a traditional brick and mortar classroom. Then I'm going to use a closed book exam where I have objective test questions, multiple choice, true, false, where I'm kind of testing, I'm testing vocabulary acquisition, I'm testing kind of the memorization of those elements, but I also always use a hypothetical essay, whether that's a short essay or a longer essay. Sometimes the exam is only an essay. If I'm looking for, if I'm really looking for a good in-depth writing piece, then I'll give an essay only exam. I usually do that at the midpoint of the semester because, again, just logistically as a professor, to turn those around in terms of giving really thoughtful feedback and grading, I need time. And if I typically can't do that quickly enough on my final exams. The way my campus is structured, I only have sometimes a few days to turn around the final exam. So a lot of times I'll do those denser writing projects at the midpoint of the semester where I've had enough time to equip them to do it, but where I still have enough time left myself to not lose my mind and turn around really thoughtful grades, because I want to give good, thoughtful feedback to the students and useful feedback that really, if I wait until the final exam, sometimes it's just not, it's not practical for me to be able to turn around those dense essay exams at the end of the semester. And B, I think it's less meaningful to the students. The course is over at that point. And so, and often, you know, you may know this too, I have a hard time even getting them blue books back. If I give an essay final exam, I usually end up being the owner of hundreds of blue books. So, I mean, I think there's a lot of ways to do that. I've also done in-class presentations. In this class, I haven't done that as often lately. I have done it. I haven't done it as often lately because I have so many individual students. I've instead gone to some small group work when I have a larger section like I have right now. And so I've done some small group presentations where I've had small groups work on a case brief together and then co-present for the class. So I'll sort of have them teach that case to the class. And that's actually really fun and effective. And I feel like that breaks up things for them, you know, where they're not listening to me for hours on end every day. It's kind of fun to have that break up a little bit. How's that, Ryan? Does that answer that question? Did I get there?
Absolutely. Thank you.
Okay. So yeah, and this gets us right at where we were in our slideshow talking about how I do it. So foundational skills, right? I teach those foundational skills, and by foundational skills, I'm even talking about for my students who need a little bit of writing remediation, some students who've never done kind of professional writing. So when you're working on the case briefs, I talk to them about what a case brief is and what attorneys use them for and what paralegals use them for and why they're important to us, and then kind of just and I give them I utilize what I call a case briefing worksheet. It's a really fancy name for just a fill-in-the-blank outline that helps them when they're first learning to case brief. And it's a tool that they can print out at home because it's an ancillary tool. It's available to them all the time. They can print it out at home. They can literally fill in the blanks when they're doing their case briefing as homework. And I ask them, bring that to class with you so that when we're having our conversation about this case in class, you can do two things. A, you can help me. You can share what you decided you think belongs in each section of that case brief, and you can explain to the rest of your colleagues. You can help them. But also, I want you to have it with you because I want you to make edits and changes. And as you hear your colleagues and in the class, and as you hear me talk about what should have been in each section of that case brief and really what the rules were and how the court applied it, I want them to make adjustments as they're listening because that's the whole point of the exercise. So for me, I'm really teaching them to learn to read to understand. And that, it sounds very, we're talking about going back to basics here, but that reading comprehension piece is not always a sharpened skill for our freshmen and sophomores. And I would dare say even some juniors and seniors, but that's something that I really want to build is those foundational skills of reading to understand. And then taking those next steps of learning those critical thinking and analytical reasoning skills. And really that goes back to that conversation around discerning the difference between legal rules and what I would call situational results. And the situational results are the outcome in this case today. So the case I'm reading today that's about Joe Smith and Mr. Brown and what they did criminally and what happened to them as a result and their conviction and the appeal and what the court said about how the law applies to their particular set of circumstances. That's a situational result. And that changes every time I change the fact pattern. And every time I give a new hypothetical, we get a new set of situational results. And so just helping them discern the difference between really learning the legal rules and really learning how to apply them to each unique new set of facts is the key, right? So I give them a novel set of facts. I might do that in class in a hypothetical situation, or I might do that on an exam where I'm assessing their ability to take that novel set of facts and really explain to me how they think the legal rules apply to them. And I talked about this just now, but unique classroom exercises and experiences. And I mean, I'm the type that I love to hear what other people are doing. I love to try it. Sometimes, you know, you try something different, it doesn't work. And in my view, that has to just be okay. We are constantly implored to be lifelong learners. And so for me, part of that exercise is trying something different. I might utilize tried and true tools like objective quizzing. I might give quizzes to make sure that I'm testing basic principles. Those are tried and true tools that I'm going to go back to every semester. I always utilize the in-depth essays to assess application of law. So that's something I do every semester. But I might mix up the rest of it, and there might be different class exercises. I might assign that case briefing journal some semesters, and other semesters I might try something different, like a presentation, and see if I had a smaller class, I might try that. I would also say I adapt a great deal when I'm delivering in an online format. I can't do the same kind of small group exercise if I'm delivering online. And I've actually, so for a lot of us, we are in the throes of changing to an online delivery, and it is not our choice. We're doing it this semester because we had to. I have taught this class in a fully online format before, even before COVID-19 forced us to. And I will say, I was still able to utilize much of what, I was still able to deliver this class, I think, using the tools that I love, which are the case studies, and I could utilize, and it's when I am really grateful that I added those full chapters to help me have a way to deliver the content, just the substantive content with a lot of clarity. And I think in a way that's very easy to read for the students and very reachable for the students, because when I'm delivering online, that's really critical. If they don't have as much opportunity to engage with me in that kind of synchronous live lecture format, even if I record and deliver lectures, or even if I make a lecture available to be joined in real time, not every student can join. That's the reality I'm seeing this semester is, while the vast majority want to, not all of them can. They can't join synchronously with me. So if I record that lecture and post it, it's far better than no lecture at all. And it's far better than having a student who's trying to learn just from reading on their own. And then, you know, maybe the kind of old-fashioned model of online learning where we would have had them read and post a comment to a discussion board, and that might have sort of been the end of it. Now, technology is enabling us to utilize things just like what we're doing today to engage our students. But I would argue there are still pieces of that that are not quite the same as a real-time engaged classroom format. And so for me, I try to do the very best that I can in this setting. I do utilize recorded lectures anytime I teach online. And so whether students are able to join me live for that, or whether students are watching that recorded, I do think there's a great deal of utility in employing this as a tool. I also modify assignments. So I typically, and this is just philosophical, there are lots of faculty who modify assignments and still attempt to have closed book exams online. I have not done that. When I teach online, I typically forego any requirement that things be closed book, because I don't like the idea of trying to police, or philosophically even police, what they're utilizing from their living room when they're taking their exam. I just think that's an unrealistic expectation for me. And so what I typically do is I would allow the utilization of resources for home-based exams, but I might modify the format significantly of the exam. And I might modify other assignments to include probably more. I usually utilize lengthier written assignments. So a bit more of a research essay as opposed to a blue book formatted in-class essay that I might do with a traditional class if I was delivering on the ground. I also love, I love the Kendall Hunt app. I use the KHQ app with my students, and I use that as it's a quizzing tool, and they love it. So if I'm giving multiple choice questions, I can share with them in the app a series of multiple choice questions for each chapter that allow them to practice their quiz taking skill. And so then if I want to give an online quiz, I mean, in an online format, I just sort of say, hey, I'm going to allow you to utilize that as a practice tool. And then I might give a timed quiz in my online classroom. So while I'm not worrying about security from the perspective of them having access to their resources, I am able to ensure acquisition of the knowledge, because if I give a timed quiz or a timed objective multiple choice test, they won't have time to look up all those answers. So they will have had to study some. So that's kind of how I deal with that when I have to transition to the online format, and I can't do, or I don't want to attempt to do that closed book exercise in my online classes. Do folks have questions there about teaching online? Are we good?
Yeah, it looks like we're running short on time here.
Okay, okay.
But in the interest of time, can I include your email address when I send the recording out?
Absolutely. And we are there. Here's our last slide, which just has any questions that you have for me. Please do not hesitate to reach out. I'm happy to help if I can. And yeah, I've just enjoyed doing this. Thank you all so much for spending an hour with me today from our houses. I know this is such a challenging season, and I'm grateful that you would take time to be here with me today.
Thank you so much, Laurie. It's been a pleasure. I'm excited to get this recording edited and sent out to everyone. And once again, thank you. And if you do have questions, please reach out to Laurie or myself, and we will get answers. Hope you all have a great day and stay healthy and well.
Absolutely. Take care, everyone.
Bye-bye.
Bye-bye.